Hi, Crime Junkie Jurors. Hello, hello, hello. Good morning or afternoon, depending on where you are. It is good to see you. Today is Thursday, July 17th, and it's Tech Problem Thursday. It took me a second to get on. My computer decided to try to update, which is bad timing. It wanted to update while I was trying to get on, and my blow dryer quit working. So all kinds of fun problems this morning. Hi, hello. It is good to see you all. Hello, hello. I have missed y'all. What have you been doing? How are things? How's your life? How have things been since the end of trial? Sup, players? Sup, players? I missed y'all too. We've been hard at work getting stuff done, but I have missed y'all. Hello, family. Sup, y'all? And we're back. Yes, the blow dryer. Look, so you can see I got this part dry, and then it died. So all of this still wet. I guess there are worse problems, right? I mean, I've had that blow dryer, I think, since 2010. So, the name of the rooftop restaurant, the one with the fireworks that we went to recently, that is called Illume. Welcome, welcome. I've actually been working at work since trial ended, so that's boring. That stinks. I bet productivity all over the country went way up. This was a nice surprise. I wasn't expected to be back until sentencing next week. Yeah, same. I didn't realize that they were even doing this hearing today. And then my mods messaged me and were like, hey, there's a hearing. Are we going to do it? And I was like, hey, didn't even know. I was working on other stuff. So unexpected, but we are here. I was in Orlando Saturday, and after the rain, it was beautiful. It's been raining here pretty much every single day. I got back to Orlando. I left the beach and got back to Orlando Sunday, and it has been raining pretty much every single day. Not all day, like Florida rain. Like right now it's very sunny, and it'll probably have like a crazy thunderstorm within a few hours, and then it'll be gone again and it'll be sunny. Chat Daddy's good. He's good. We went cold turkey without you. I was going through withdrawal, right? I think we have decided, I'm pretty sure, but we're just working out the final details. The verdict ended my loud yelling at Mr. Brennan. My neighbors are happy too. That makes sense. That makes sense. This hearing is supposed to be about the gag order. Lucy's like under my chair. Scout is asleep in Lucy's bed right now. So we've got a little bit of zoo crew drama going on right now. Did you hear that Bev got moved to circuit court? Yes. Bev got moved. She's only doing civil stuff now, which is mostly what she did before. I mean, she's done criminal too, obviously, but I think they said most of her docket before was civil. But yeah.
All right, we are on the record in State v. Kohberger, CR 0124-31665. Present today by video is the defendant in custody with counsel, Ms. Taylor, Ms. Barlow, and Ms. Massoth. State is represented by Mr. Thompson, Mr. Hurwitz, and Ms. Jennings. On behalf of the media petitioners, we have Ms. Olson and Mr. Pedersen. Today's hearing is to discuss the media's request to terminate the non-dissemination order. The state filed a response indicating it was no longer objecting to that, and the defense did file an objection indicating that they do have a continued objection to lifting the non-dissemination order. I've read the briefs that have been provided by the parties, and I'm going to attempt to shortcut things here a little bit by asking whether the defense, who is the objecting party, has anything additional to add beyond what it had in its briefing before. I don't know that I need to hear from, frankly, the petitioner. I think the briefing was adequate, so let me just start with Ms. Taylor to see if there's anything else she wants to add.
Your Honor, there is not, but if there's further argument, Ms. Barlow will be making that argument on behalf of the defense.
All right. And to be fair, Ms. Wilson, was there anything you felt was important to add that was not contained within your briefing?
Your Honor, we would just briefly say in response to the defendant's brief, we certainly understand the expressed concern about the media coverage of their client. We don't think continuing the non-dissemination order helps that at all. It simply continues to limit the ability of the members of the press to reach out to the people who know the most about the case. It doesn't obligate them to say anything. We also understand that they expressed that there was a due process right related to the sentencing. I read the case that they submitted. I think that there is obviously a due process right at sentencing, but I don't think that case is really it doesn't provide any guidance to the court here, because that was about information provided to the court, and given the very limited scope, and we understand it's very important, but given the very limited scope of what's to be decided at the sentencing, we don't think the arguments that Mr. Kohberger made should outweigh at this stage the First Amendment rights of our clients. Thank you, Your Honor.
Thank you. All right, in light of that response by the media outlets or interested outlets, Ms. Barlow, do you want to add anything?
I would only say, Your Honor, as this court is well aware, the publicity in this case is so extensive and emotions are already so high that adding fuel to the fire of media interviews or a rush to interview people as they leave the courthouse or enter the courthouse would only increase the concerns that the defense has. And even though the plea has a specific sentence attached to it, as this court is well aware, things happen in plea hearings and, sentencing hearings. And to minimize the possibility of that, we request that this order stay in place.
Like what? What do you think is going to
you.
happen?
All right. As the court has considered the petition, frankly, the court was prepared at the time the plea was entered to lift the non-dissemination order in order to give the parties time to evaluate that and to ensure I wasn't missing anything. When both sides objected, I agreed to continue the non-dissemination order. I also indicated that I would have the potential to look at that again before sentencing, because frankly, I anticipated the motion from somebody, in this case, the Ms. Olson and her clients, was likely to be coming. And at this point, I do not believe the purpose of the non-dissemination order, the primary purpose, which is to ensure that we can seat a impartial jury, is any longer at play. The concerns identified by the defendant, while certainly not to minimize those. They are concerns, and they are significant concerns. I do not think, however, the non-dissemination order and the right of the public to information is outweighed or outweighs those rights, I should say. And frankly, I don't think that lifting the non-dissemination order will meaningfully impact those concerns. I mean, the media frenzy, as it has been described, will continue regardless. It is a little bit like water will find low ground. In this case, the media is going to write about something regardless about this case. The lifting the non-dissemination order does not require the counsel or others who were previously bound by it to speak. And the state has indicated that they don't intend to until after the sentencing. And certainly I would hope that the media interests would respect those positions and give people the space that they need and request. In terms of, for example, the defendant's family and others coming and going at the sentencing, we intend to have, as we did before, appropriate security measures in place to ensure that they, as well as the victims, are allowed to get in and out unscathed by the media, if that's what they wish to do, or if they wish to speak to the media, they can do that as well. At this point, I just don't think that I can justify the continuation of the non-dissemination order. I think the rights of the public to information in this case is paramount, given the fact that a plea has been entered in this case, and so I'm going to lift the non-dissemination order. But I want to point out what that means and what it doesn't mean. So obviously nobody's required to speak to the media, first of all. Second of all, I want to be clear that the court's prior preservation order to the parties is not lifted and continues to stay in place. And so it's important to understand that those obligations still exist. And then the other thing I want to point out is that by lifting the non-dissemination order, that does not convert sealed documents to unsealed documents. Documents previously sealed by the court are still sealed. Now, I see the media also filed a petition to be heard to unseal everything. I'm denying that outright. The request to intervene, because I think it's premature at this point. So the court will its intent is to, after sentencing, begin the process of reviewing all the sealed material in this case to determine what should be unsealed and what should not be unsealed. That process will include an opportunity for counsel to register any objections to unsealing documents, specific documents, and request to redact certain sealed documents before they are unsealed, or unseal them in a redacted form. I intend to do that in groupings of documents at a time. As I sit here now, my thought is I'm going to start from newest to oldest, because those are the ones that I have the most working knowledge of as to the reason for the sealing of the documents, as well as the content of those documents. And so I think I can get through those more quickly. As we move backward in time, it's going to take further, more extensive review by the court to figure out, to obviously review the content of those documents, listen to those hearings, et cetera, and determine why they were sealed and whether that rationale still is necessary, or that rationale still requires the documents to maintain that sealed status. And so before everybody gets out their pen and paper and sends in public records requests, understand those will be denied for sealed records until they are unsealed. And that process is going to take time. And I'm not talking days. I'm probably not talking weeks for that to be accomplished. So I hope people understand patience will be required to get through that, as I'm going to have to review those myself to make those decisions. Now, we may be able to speed things up if neither party objects to groupings of documents or specific documents being unsealed. But it's important to review those because those documents may include information that, pursuant to Rule 32, are not to be made public, including birth dates, social securities, information about minors and victims, and information that would be essentially inappropriate to unseal, including protection of individuals from undue harassment, et cetera. And so that's just going to take time. In addition, I'm unlikely to unseal much until after sentencing and after the appeals period has run. Now, I recognize the plea agreement includes a waiver of the right to appeal, but as the parties probably know, the U.S. Supreme Court in Garza versus Idaho has indicated the fact that a defendant waives the right to appeal doesn't mean they don't have the right to appeal. And so it may affect the outcome of that appeal, and it may affect the underlying case and the plea agreement. But nonetheless, the right to appeal does not go away because of the waiver. And so I think it's important for that time period to also play itself out to see that it goes the way that I think people intend and expect it to. And so I will be entering an order in the next week or so outlining the process for the review of the sealed records. And counsel will need to maintain a presence in the case in order to review those materials as they are proposed to be unsealed by the court. Because the timeline that I will likely give you will not be, I suspect, extensive as for each group of records. So I might give you 14 days, for example, to provide a response as to a group of, a dozen or a couple dozen records at a time. So just sort of heads up and fair play with respect to that. Any questions by the parties about the ruling today?
Not from the state, Your Honor. Thank you.
No questions from the defense. Thank you.
So Olson, do you have any questions?
I don't, Your Honor. I wasn't certain if I was included within the parties. I would just say I think that the court's proposed manner of moving forward on the sealed records will likely largely address our interests, and we appreciate the court setting that out in this hearing today.
Yeah. If certain records after review maintain their sealed status, it would be at that point that I would entertain requests for me to consider that more formally and to have a voice in that. But I think until I've gone through that process, it's premature, which is why I don't intend to take up your motion, your more recent filed motion at this time. So,
thank you, Your Honor. We appreciate that.
All right. And with that, then we are adjourned. Thank you. I'll see you next week.
Thank you, Your Honor.
Quick and easy. That's it. What are we thinking? How are we feeling? That was quick. Yeah. Waiving his right to appeal, I guess he said he can still appeal. It's going to change the outcome. He's not going to he did lift it, but the things that are still sealed are going to remain sealed for now. He said that, which is good. That's fine. There are some things after the sentencing is over. They are going to start going through all of the documents that are sealed and see what needs to remain sealed and what needs to be unsealed for the public. So. Yeah, I guess waiver to appeal isn't really a waiver. But he said it would affect the outcome, so I'm assuming he can try it, but it won't work. The law is always changing. So the gag order, though, is going to be lifted. Yes, this will benefit the media. So the gag order was originally put in place because they wanted to protect, right to a fair trial by keeping anything that's like extrajudicial stuff out of the media so that it's not available to the potential jury pool. But then there's this like media coalition who has filed this request to have it lifted. It's like, I can't remember who all it is. I know it's like Associated Press, Fox News, is it the Argonaut? It's like the local one. And then the student paper and whoever else. There's like a bunch of them. But anyway, it's like this media coalition. And they are now saying, okay, since there's not going to be a trial, this gag order is restricting public access to information, and that infringes on First Amendment rights. So they are wanting the gag order removed to allow for greater transparency, for understanding of the case. Because remember, part of his plea deal, he did not have to explain anything. He just had to get up there and say, yep, I did it. So he said, yes, he will lift the gag order, which is great. But the other part is that there is a request to have all of the previously sealed documents unsealed. And he said that he is denying that motion because it's premature to do that at this point. So after the sentencing is over, then he will review the stuff that's sealed and then see what should remain sealed and what should be unsealed. Every trial is going to have stuff that stays sealed. It's part of it. Everything, there are things that the public does not need to see, the things that the public does not need to know. So there are always going to be things that stay sealed. But it's just a matter of going through it to say, okay, like the media can know this now. This can now be part of the public record where it couldn't before. So. I don't know exactly what they were talking about with that impacting him during the sentencing. Like what? How does that? I don't understand how that impacts him in a negative way, but so what can come out now? What that means is that the lawyers and investigators are no longer under a gag order to talk about everything, and they can do media interviews. They can, which, there was a big deal about how inside sources told Dateline this and this and this. So, they had, I guess, a leak somewhere anyway, which is a big deal. But now there's no reason for it to be a leak. Now they can actually talk about the details now. So A lot of the friends talked in the Prime doc that just came out. I watched that and I thought it was really good. It also cleared up some things that were, I think, questions that had kind of remained unanswered. So I thought that was really good, especially like the 911 call. That part I think was probably the most clarifying thing. Oh, it's just heartbreaking too. And it also gave some great insight into some of the like YouTubers and online sleuths who have kind of terrorized those kids. Yes, why the 911 call was unresponsive or unconscious or whatever it was. It's something that I've always been like, I don't understand why that is. It's just always been one of those things that like, but that's the perfect example of how we can't have things cleared up. Like, so it causes all of this, it's caused all this speculation because we aren't allowed to know so many different things. And when I listened to that, I was like, oh my gosh, like, okay, that part makes sense. Those are the kinds of things that you wish that it could be made public and could be told, because those are the things that make it make sense. And instead you have people spiraling over things like that and, you know, coming up with other scenarios to explain it. It's really sad. Yeah, he was trying. Yeah, it was a great documentary series. So, anywho, well, sentencing will be next week, so we will be back here. That is going to be a difficult. That's going to be difficult. Because for that, hearing the victim impact statements and all of that, that's going to be tough. So bring your tissues. Can you tell us what you're working on? I'm working on season 3 of the podcast, and I am so excited. I cannot wait for y'all to hear it. So excited. Been working my little fingers to the bone. I think he stalked Maddie online and figure out where she lived. I think so too. I said this, I was on Court TV talking about this case last week. Was it last week? I don't know. All my days are running together. And I said the same thing. I think that Maddie was the target. What cases? Y'all see. Y'all see what's coming up. I'll let you know. Tissues and waterproof mascara ready. Yeah. Oh, it's going to be difficult. Are the roommates going to speak at the hearing next week? I'm not sure who all is going to give their victim impact statements, but I mean, they definitely could. It's going to be hard. Was Ethan asleep? I think they said, yeah, I think they said Ethan was asleep when he got there. Do we think that he will keep showing no emotion during their statements, victim impact statements? What do y'all think? I think so. I don't think he'll show any emotion. I could be wrong. Such a sad situation. So sad. So next week we have, what is it, Thursday or Tuesday or Wednesday? Wednesday? It's the 23rd, whatever the 23rd is. Wednesday? Okay. So Wednesday, we will have the, we'll be live for that, it's going to be tough. It's always one of the toughest parts. Yeah, the judge cleared his docket for Thursday as well, just in case. It may all be done Wednesday. We'll see. I'm supposed to leave town on Thursday, so let's hope it's all Wednesday. Have his parents talked at all? Not that I've seen. I haven't seen anything from them. All right, y'all. Well, short and sweet. I appreciate y'all coming and watching with me, hanging out. We will be back together on Wednesday of next week. Don't forget, set your reminders. Don't go. You know what trial that was from? Don't go. Latisha. That one gives me a headache. All right, y'all. I appreciate you all. I will see you bright and early on Wednesday. Well, they're not our time zone, so it might not be like super early, but it'll be early-ish. So I will see y'all on Wednesday with a box of tissues, emotional support, zoo crew, and no mascara. I love you all. I will see you then.